Good afternoon and welcome to today's webinar on protection of risky assets. Before we get started, if anybody gets disconnected, please call our phone number at 561-953-1050. If you're not already receiving our weekly e-newsletter, please let us know and we will be happy to make sure that you're receiving the newsletter and get you on the email list. We also do complimentary consultations on asset protection, estate planning, and generally anything having to do with those two topics. So you can always feel free to give us a call or contact us and we can set that up. If you have any questions during the course of the webinar, you can try typing them in the chat box. Sometimes I can address them. Sometimes it gets a little bit distracting. So try typing it in the chat box. If I can't get to it, then we will email you with the response to your question. In addition, we do speaking engagements. Many of our attorneys are well-trained speakers on these subjects. So if you have a large group that would be interested in that, please also contact us and we will do what we can to set that up. A little bit about myself, let's start with that. My name is Elise Gross. I've been an attorney for over 25 years in South Florida with a practice in estate planning, probate, and asset protection. I'm an adjunct professor at Florida Atlantic University where I teach the paralegal students estate planning. So what are we going to talk about today? Today we're going to be talking about protecting risky assets. And we're going to talk about what actually are risky assets, why do we have to treat them differently. We'll go through some strategies, and then most importantly, some things that you have to be aware of when you are protecting the risky assets. So let's talk about what actually is a risky asset. The one that most people know about is real estate. So when you own something that's a piece of property, whether it's vacant land or it's a house or it's a building, there's a potential for liability because if something happens on that property or with that property, somebody could potentially sue you. And as an owner of a piece of property, you do have a high vulnerability. But on the other hand, it's one of those assets where you could also have a large amount of equity. So you want to make sure that you protect those assets. Now, we have to differentiate the assets, the real estate that you live in, your home, versus a property that you rent out or don't live in, an investment property generally, or a vacation home. Because if it's your home, while owning it could be a potential risk, depending on where you live, you might have some protection built in via homestead statute. For instance, I live in Florida. We have an amazing homestead statute here. So if I have my home, most creditors aren't going to be able to take my home if they sue me and get a judgment against me. That doesn't mean if somebody slips and falls on my property or gets poisoned or whatnot, that they can't sue me because they can, in which case potentially my home is vulnerable. But because it's your home, because you live in it, because of the income tax laws that exist, you probably are going to want to keep your home in your own name or you and your spouse, because there's the cost benefit analysis of moving your home from your name is different than having an investment property. So because of that, we're going to keep the home outside, in your own name, outside of any structure, most of the time. However, part of our process when we're interviewing a client and getting all of their information is assessing each and every asset, how it's titled, what it's worth, what state you're in. So we will address the home if we feel that it is more vulnerable because of the state you're in. And then you'd have to make a cost-benefit analysis based on income taxes as to whether or not you're going to want to do something and transfer that asset into another protective entity, which is what we would normally do for real property. So we'll get to the strategies shortly, but real property is definitely one of the most common what we consider risky assets. The next two kind of take together. That would be a boat and a plane, or even things like a jet ski or, tractor trailers, RVs, anything of that nature where somebody is driving and therefore it's a liability. Somebody could get hurt. So it's not just that it might be an asset, but somebody can be hurt by the driver of the boat or plane or, whatever. Let's call them toys. We like to refer to them as toys. So we always have people who come in and will say, oh, well, I have this really old boat and it's only worth like $10,000 or $15,000. So we'll say, okay, from an asset standpoint, it's not a big deal because it doesn't constitute much of your portfolio. However, from a liability standpoint, it is a high liability producing asset. Therefore, it may not be worth much, but the amount of liability it will cost you could be huge and would impact everything else that you own. So these are assets that we have to protect. Operating businesses are a very interesting feature here, because if you have an operating business, depending on what you're doing, there's always potential for liability, and there's always potential for it being a large part of your portfolio. So if your business is successful, then it's great. It's a wonderful asset. If your business is successful, it could also be a huge liability because you have employees potentially. You are selling products, which can cause injury. You might be manufacturing products. You might be providing a service and advice that could potentially open you up to liability. So operating businesses can be a huge asset, but can also be a huge liability. And then here's another thing that we always evaluate, and we're going to talk a little bit later on about special strategy that we use with owning things with joint ownership. So I'm not talking about owning a business with your spouse or owning a property with your spouse or owning a company with your spouse. I'm talking about someone other than your spouse. And I mean anyone other than your spouse. That could be a sibling. It could be a friend. It could be just, business partners. Those are, while they can be great assets, the ownership of that needs to be structured in such a way that you are protected. Because even if you have a company, maybe it's an LLC, a limited liability company, that is the operating business, and you own that with somebody else, we have to question how you should actually own your interest. Do you own it in your own name? Do you own it in a trust for estate planning purposes, or do you own it in some other way or a mixture thereof? We just talked about what might be risky assets, and there are others, but those were the main groupings. So why do we have to treat them differently? Well, let's compare owning a bank account with $1 million versus owning a rental property worth $1 million. If you own a bank account, it's in your name. So we would need to do something to protect it. Maybe we put it in an LLC, we put it in a limited partnership, maybe it goes into retirement. There's a lot of things that we can do to structure that, but we're not really worried about that asset causing any liabilities. We're strictly concerned with protecting the value of that asset. If you contrast that with a piece of property worth $1 million, well, it's a twofold process there, because now not only are we worried about protecting the equity in that property, we're also worried about that property causing liabilities, which could cause the owner of the property to be personally liable for any injuries or any issues with that property. And if it's in an entity, we have to think about the fact that the entity itself could be liable, and therefore the asset itself, the piece of property, might be vulnerable. So when we talk about strategies, we'll talk about how we identify strategies dealing with the real property, and there's different ways to go and different layers that we're going to discuss. So passive investments, I'm not worried about passive investments because, if you have something with a financial broker, your chances of there being any sort of litigation with regard to the asset, it's not a definitely no, but it's a possibility, but it's a very, very remote possibility. Maybe you get into some sort of a controversy with the broker, they did something wrong and you have to sue them, or there's a margin call or something of that nature. But if you're not buying on margin, for the most part, those passive investments are either going to grow or not grow, but there's really going to be no liability with regard to those assets, meaning they're not going to cause you to be sued and they're not going to cause you to have to sue someone. So what we do with those passive assets is going to be different than what we do with assets that are risky, like the real estate, like the boat, like the plane. We also, as part of our strategies, we're going to talk about segregating risky assets from each other and from the passive investments, because we want to make sure that if you structure your asset protection plan in such a way that even if one asset is a very risky asset and actually causes a problem and actually does get taken by a creditor, that it doesn't affect all the other assets that you have. So a good asset protection plan is going to look at it all and play it out so that they're going to diversify the risk and segregate out the risk so that you're minimizing exposure. Doesn't mean there won't be any exposure. It just means that you can plan so that you're minimizing that exposure. So let's talk about strategies. So there's a bunch of different strategies that you can employ, and a lot of them have to depend on what the assets are. They might depend on where the assets are located, and they might depend on your palette. What can you handle? Can you handle international? As long as international entities are set up properly with the right people, with the full information to the IRS, there is absolutely nothing wrong with an international strategy. And if it's proactive, that's the best way to go as well. As long as everything is done properly, nothing wrong with international. However, not everybody has the taste for it. You have to be able to make sure that things are done properly from not just when you set it up, because that would be our job, but moving forward. Is accounting being handled properly? Is the IRS being given all the forms and filings that are required? Are you complying with whatever due diligence the international counterparts require? Are you doing everything legally and ethically? As long as you're doing all that, international strategies might be what you're looking for, or at least a part of the strategies that we're employing for you. So that might be for things like passive investments. If you hold them internationally, which I'm not going to go much into today because that's really a subject for another webinar, but if you hold them internationally, then essentially you're putting them, for the most part, beyond the reach of creditors, except for very, very aggressive creditors who may or may not be willing to go the extra mile to attempt to get at the assets that are held internationally. Even if they do go after them, chances of them recouping are pretty slim to none if you've done everything correctly. But by putting assets outside of the reach of creditors internationally in a legal and ethical manner, you're putting yourself in an extremely good position. With that said, not every asset can really be held internationally. For instance, you can't move a piece of real estate. There are other strategies you can employ to protect that real estate. You might be able to use financial strategies that what we call equity strip out the property by putting legitimate loans on the property that are recorded mortgages. And there's, expensive strategies that can be employed that are very good and that are completely legal. There's a lot involved, many moving parts, but you can do that and essentially rip the property of all of its equity or majority of its equity. So if a creditor goes looking, they're not really going to find anything too enticing about that property because it doesn't really have equity in it. There's also the concept from a domestic standpoint of the limited liability company. Now, we like the limited liability company. It's only been around for 40 odd years, so it's a newer animal than, say, the limited partnership, but it's good for assets that are risky. And the reason it's good is that it's a way of being able to separate out the assets from segregating them from each other, giving the owners, who we call the members, and the controlling parties, who would be either manager or managing member, depending on what state you're looking at or what country, insulating them from liability from anything having to do with that LLC, unless, of course, they do something negligent, in which case they're going to be held personally liable anyway. So if I own an LLC, if I own a membership interest in an LLC, then I'm going to be insulated as a member and as a controlling party from anything having to do with the LLC. It doesn't mean if that piece of real estate is held in the LLC and somebody gets injured on the property and they sue the LLC, they won't be able to get any judgments against me, whether as a member or as a controlling party, manager or managing member. They will, however, if they're successful, get a judgment against the LLC and they could take the property, which is just something that, that's the risk. And if you have equity in the property, then that's the potential that will happen, which is one of the reasons why we don't put more than one property in one LLC. Because if somebody's going to sue the LLC, why would we ever want them to be able to get two properties when only one of them was the cause of the injury? So you always want to segregate out when you do the LLCs. So that's why we really like the LLC. It's simple, it's easy, it's relatively inexpensive to set up, as long as it has the proper operating agreements that dictate all the best possible terms, both protected for the owners and the managers rather than the creditors. If you've got all that, if you're respecting the integrity of that LLC and you've got the bank account and you're running it the way it should be like any other business, then an LLC is great and it works wonderfully. But again, don't put too many eggs in one basket. Don't put more than one property in an LLC. Now, I get asked all the time, well, it's such a pain to have more than one LLC, and then maybe there's additional tax returns and bank accounts. And while I want the protection, I really don't want all this complexity and all the returns. Can I put more than one property in one LLC? So the answer is sure, you can do whatever you want, with the understanding that if property A has a problem and a judgment is obtained by a creditor against that LLC, then all the other properties, B, C, D, however many you have in there, are vulnerable to that particular judgment. The only time you really want to consider putting more than one property in an LLC, and again, it would not generally be our recommendation, is if you're going to do a cost-benefit analysis. And let's say you have Section 8 properties or investment properties that are really worth, under $100,000, and you have many of them. Well, you could consider combining them and putting some of them in one LLC and then some of them in another, so you can have, if you have 25 properties, which we've had clients with 25 properties, one client did 25 LLCs, another client who had 25 did 5 LLCs and put 5 in each. Again, it wasn't our strongest recommendation to do that, but they did a cost-benefit analysis. They took insurance, which is always the first line of defense. You always want to do the insurance no matter what structure you use. And they figured they'd take their chances. My guess is if they were ever sued and got a judgment against the LLC, they would start doing things differently. moving forward from that point. But they did a cost benefit analysis and said, we'll do 5 in each. They're small properties. Altogether, they're maybe worth, $600,000-700,000. We're willing to take the equity risk and then just keep it heavily insured. So it is something that you can do with the understanding of what the risks are. Okay, that one property is going to essentially infect another property. Okay, so that's the LLC. So the LLC is great. Why? Because it protects against the managers and the members. It gives them insulation of personal liability for anything that happens with the LLC, other than from a negligence standpoint. We also have to evaluate, why is an LLC so great if you personally own an LLC and you get sued personally for something else having nothing to do with this LLC? Well, what's great about it is generally, depending on where the LLC is located, depending on where you live, you have charging order protection. And in some states, charging order is the exclusive remedy that a creditor has against your interest in an LLC. So if you had, and I'm going to contrast the corporation versus the LLC. If you had shares in a corporation, whether it's a corporation that you run or have an actual participation in, or even shares in Facebook or IBM. If I'm a creditor and I get a personal judgment against you, no problem. I can foreclose on those shares, take them over, and you're out. Not a problem. If you have an LLC and the charging order is in place, the judgment will entitle the creditor to get a charging order. They'll have to ask the judge for it as a remedy. The judge will issue the charging order, and the creditor will not be able to take your membership interest. They will not be able to inspect the books and records. All they'll be able to do, they won't even be able to vote for you. All they're able to do is if the LLC issues a distribution, the creditor can stand in the member's shoes and take the distribution. Depending on whether or not you're the controlling party of that entity, you might be able to control whether or not there are even distributions. So the creditor could sit around and wait, and get nothing, which puts you in a very good bargaining position to settle out the judgment. People who are thinking of asset protection don't really consider that they're probably never going to want to live with a judgment. So it doesn't mean if you do an asset protection plan and you do it proactively, the best way it can be done, that you'll never write a check. It just means that you want to write the smallest check possible. So you need to be in the best defensible position. So when you're dealing with a risky asset, generally the LLC is the best way. And hopefully you're in a state where there's good charging order protection, because that's the best possible scenario for you. So risky assets, LLCs, good plan. Well, the question is whether or not you should own that LLC, or whether or not that LLC should be owned by another entity, or directly through your estate plan, like through your revocable trust or an irrevocable trust. And it's really a case-by-case analysis there. But if you think about it, if you own the LLC directly, so you're the owner in your personal name or in your revocable trust, which is basically the same thing, then while you could be insulated as a member from liability, and a charging order would only be against the distributions, well, what happens if you decide you want to sell that piece of property and take the money? That would be a problem, because if you sold the property, you sell it inside the LLC, okay, nobody's taking that, but how would you get the money out? If you have to make a distribution, then your creditor is going to stand in your shoes. So one way to consider is to actually multi-layer it. So don't own the LLC directly. Maybe own the LLC inside a limited partnership, which also has protective structure. So the LLC might be owned by a limited partnership. And then if you want to sell the property, the LLC sells the property, gets the money. And then instead of making a distribution to you personally, who has a judgment against you, they can make the distributions into the limited partnership. You can dissolve the LLC, be done with it, and continue investing the money in the limited partnership. It's beyond the scope today to talk about how you get the money out of the limited partnership other than as a distribution, but suffice it to say there are strategies to be able to handle that, but at least you had a place to park the money. That's the simple scenario. Let me give it to you more clearly, and you could really see the difference. Let's say the LLC owned a piece of property and you only owned 50% of the property, and you had a partner who owned 50%. So you were the member and the 50%, the partner was a member for 50%, and you decide the partner wants to sell the property and the partner wants to get the money. Well, the partner wouldn't be able, call them the innocent partner, would not be able to get any of the money out, because if you had to make distributions, you'd have to take your distribution too, and then your creditor would take your money. However, if your LLC was owned by the limited partnership, then your partner can get the distribution to himself, and your distribution would also be made, but it would be made up the chain to the limited partnership. So having that second layer in place really provides you with a great receptacle to be able to liquidate assets, whether it's a business or a piece of property or even a boat, a plane, or whatever it is. It allows you the flexibility, especially if you're dealing with somebody else. You're not holding them up, because then they'll sue you for partition, and then that's a whole other ballgame, and you're going to have a big issue there. So this way, everybody gets what they want other than the creditor. So now I'm always asked about integrating estate planning. And since estate planning is one of the major things that I do, we take it upon ourselves to make sure that every client integrates their estate plan with any asset protection plan that they've done. Because there's a lot of different facets to asset protection, and which, by the way, I call integrated estate planning, because it really works together. In order to have something to leave to your children and to your spouse, you have to protect it. So you've got to do the asset protection plan in order to have the estate plan, because if there's nothing to protect and there's nothing to pass on, why bother? So we integrate it by, if you have trusts, we put the trusts at the top of the food chain so that the trusts will own the highest level of entities, so that ultimately, when all is said and done, when you pass, everything wraps up into your estate plan. So a well-done asset protection plan is going to be protective, but also integrate with your current estate plan. Sorry. Okay. This is what I was alluding to earlier. When you have a partner, maybe you want to employ a different type of strategy with that. So if you have no partner and it's just you, we talked about you can have the LLC. The LLC might be owned by a limited partnership. The limited partnership will probably majority be owned by your revocable trust if you have estate planning, or it's you if you don't have any estate planning in place, which is great. You can liquidate, you can put the money up through the limited partnership, no problem. If you have a partner, you can do the same thing. You can have an LLC for the asset, whether it's the business or the property or the plane or the boat or whatever it is. You want to liquidate, no problem. The LLC liquidates, your portion goes up into the limited partnership. Well, what happens if all your assets are in the limited partnership and you have a joint asset with somebody else and you get into a fight with that other person? So now you're litigating with the other person, and the owner of that LLC is not you, but it's your limited partnership, which potentially makes your partnership a plaintiff or defendant in this lawsuit. If you lose, then everything in your partnership is now vulnerable against that lawsuit. So one of the things that we look at is maybe putting what we call a conduit in between your limited partnership and your investments with other people. So this way, call it ABC Holding Company, owned by the limited partnership, now takes interest in Main Street LLC, which owns a piece of property. So now, if there's a dispute with your partner in Main Street, ABC Holding Company is now the plaintiff or defendant, and your limited partnership doesn't get involved. So we always want to make sure that the limited partnership isn't in a position to be sued or to have to file an action, because we don't want it vulnerable. So when we look at whether or not to do a conduit, we look at, do you have a business or an asset with somebody else other than, let's say, your spouse or probably your children? Is the underlying LLC a member managed LLC, meaning the parties that own are also the managers? That's a possibility that we want to consider having a conduit above. And also, for a privacy standpoint, depending on what state the LLC is structured in and set up in, is what information is available to the general public online. So if you're in a state where it lists the actual members of the LLC, you probably don't want your limited partnership being listed on a public website, because if it's going to hold a lot of your assets, now everybody's going to know of the existence of the limited partnership. So what we would do in that case is we would consider using a conduit in between the limited partnership and the actual LLC itself, so that what's listed on the public website in places like, I think, Alaska, Arizona, few states have it. You would have this ABC Holding Company is listed as the member, and ABC Holding Company might be in a state where you can't look up ABC Holding Company's owners or managers. You have no idea who's even involved. So you have some options there when you use this holding company. And there's a question as to whether or not you should have multiple holding companies with every group of partners. So if you have one set of partners, you probably want one holding company. If you have another set of partners, you'd want another holding company. Ideally, that's the way you want to structure it, because that way you're again segregating assets from each other. And by putting together this kind of plan, you're basically putting yourself in a wonderful defensive position. Again, we talked about whether or not you want to have a judgment against you. Most people just don't want a judgment against them. They don't want that hanging over their heads for the rest of their life when they can't have money in their own name, because it could be garnished at any time. So you have to make sure that you're structuring yourself in the best possible way to make yourself the best possible defense if there's a judgment against you, so that you can make the best possible settlement. And we're about to talk about what you need to do. What are the caveats that you have to look for once you go through this and set up your plan and do everything correctly? Moving forward, if you don't do it correctly, then you've kind of negated everything that you're doing. So I'm going to discuss it on the next slide. When you do have an entity that discloses members and you do consider doing the conduit, you have to make sure that you're keeping up with the information, making sure that information is always what's viewable online and that you're not changing it, because people forget over time and they forget why they did something in the first place, and sometimes they mess it up and change the information. So these are the things you have to really be wary of. Once you set up this plan and you've taken that next step and the plan is in place, what do you have to do? Well, you want to always make sure, because we truly believe in insurance. Insurance is a great first line of defense. You want to make sure all your insurance is in place, whether that's getting an umbrella policy, whether that's just making sure you have the right property and liability insurance on all your assets. But you have to make sure that if you've changed the ownership or you took ownership inside an entity, that you are insuring the entity in the entity's name. You also may, depending on what the asset is, you may be insuring yourself as an individual as well. So for instance, if it's a boat or a plane, well, you're the driver, so you need to be insured individually as well as under the company. Because the last thing you want to do is now it comes time to file a claim and you find out that, well, the insurance was not in the proper name and they're not going to honor your claim. So insurance, absolutely great first line of defense. Make sure you have as much as you can. It's fairly cheap to get liability insurance, umbrella insurance, property insurance, whatever it is. Keep it in place. Make sure it's in the right names and you have the right coverages. And be aware of your coverages because not everything is covered. So you want to make sure, to understand your coverage. The next thing that's so critical is keeping your entities in good standing. Just because you filed them and created them in year one doesn't mean that they stay in good standing and operative if you don't file annual filings with the state if they're required. It may just be paying a fee. It may be putting in information, verifying information. Make sure that you are on top of that and you don't miss deadlines. If you miss deadlines, aside from the monetary penalties that the state can assess you, your entity can be dissolved. In which case, when you then get sued, you don't have an entity in good standing and they might try to get you personally. Or if you want to sell an asset or transfer an asset, if you're not in good standing, there's really nobody who has the authority to do anything. So you always want to make sure that you're filing whatever you need to file, that the filing information is consistent with the true information of the company, who are the current managers. If it's a state where it lists the members, make sure you're listing the members and that everything is exactly as it should, even addresses, everything needs to be properly done in order for that to stand up when you have a lawsuit. Registered agent. If your entity is in a state where you don't live, you're going to have a registered agent employed for that company to receive any lawsuits if they get filed. Generally, you're going to use a corporate registered agent. That means they get paid every year. Don't forget to pay them because they will resign. If they resign, your company is no longer in good standing. You've got a problem. It means there's nobody to serve. If they can't serve a company, guess who they're going to try to find you? They're going to try to find you. Respecting the integrity of your structure. So that's really the next two. You got to maintain a separate bank account. So I know it's annoying, but even if you have a piece of property and you're not renting it out, but it's your vacation home, but it's an investment property because it's not your primary residence, have a bank account for it. Put the property taxes and the mortgage and insurance and everything through that account. Keep segregated records. You want to respect the structure because if you don't, why would a creditor or a judge respect it? So maintain separate bank accounts and separate books. Keep good records. Make sure you always have a signed copy of the agreement. Doesn't necessarily have to be an original, but it needs to be signed. If you make any changes, make sure you keep the others from prior. Make sure you always have signed signature pages. I can't tell you how many times I've seen where people come to me and they're like, oh, well, here's the operating agreement. And I say, well, it's not signed. How do I even know that's the operating agreement? Or maybe it's signed by one person, but it's not signed by the other. Well, guess what? If you don't sign it, you're not technically bound by it. So you don't really have a fully operational operating agreement. Make sure there's membership certificates, every piece of paper that can be produced in the event of a lawsuit is good for you if it's structured properly. But the more paper, the better. So maintain those records, maintain the bank account. And lastly, and probably the most important thing, is always file the tax returns. You may have an LLC that doesn't need to file its own return because it's a single entity, a single member LLC that winds up through another entity. I would still have a tax ID number for it. I would still make sure that the accountant files a schedule for that entity. If K1s need to be issued, issue K1s. Do everything you need to do so that the structure is very clear on those returns as to who owns the entity and what portion. Because one day there might be a dispute and you're going to have to prove who owned the entity and for how long. So you need to make sure that tax returns are being filed, that there's no delinquencies, and that they're all being filed with the correct information. It happens all the time. I see it every single day. So these are things that you need to make sure of. So that's all we have for today on protecting your risky assets. If you have any questions, feel free to email us, call us, and we'll be happy to answer them for you. If you want to get on our newsletter, if you're not already on it, please let us know. If you want complimentary copies of our books, our managing partner, Mr. Presser, has written several excellent books on asset protection and strategies. And if you're interested in a complimentary preliminary consultation, we're happy to hear from you. Next month's webinar is an estate planning webinar, topic to be determined. It is on March 19th at noon Eastern Time. Thank you so much for joining us this afternoon, and we look forward to hearing from you.